what. Okay, can everybody hear me? All right. So I laughed because, first of all, I know Sherry didn't say that. I know that Sherry, when she found out that she wasn't coming, she would have hoped it would be anyone other than me who could do it, but unfortunately, that's not exactly true, but I'm speaking immediately after her, so it was just too convenient for her to pass up. Also, it's true that when she did explain these slides to me, she was whispering, with the result that she gave me some speaking points, but whispered them out, and I whispered them back to her, as you often do when someone is sort of whispering to you. So you may find that when I'm trying to make the most important point, my voice just sort of drops, because that's how Sherry did it to emphasize the point. But that said, let's start going here. So what are we going to talk about over the next hour? So mandatory breach reporting under PHIPA. So as many of you know, that's come into force for about 2 years. Annual statistical reporting. Significant PHIPA decisions in the last year. There's been a few of those. Some new PHIPA guidance documents that are either out or about to come out, and then what you can expect a year ahead. Mandatory breach reporting. So more than 2 years ago, which is hard to believe, you now have to, custodians have to notify the IPC of certain types of privacy breaches. They fall into different categories in the regulation to PHIPA. It's in Section 6 of the reg. The first category is a use or disclosure without authorization. Now, really what that means is a use or disclosure without authorization where the person knew or should have known that they shouldn't have been doing what they were doing. You have to report stolen information, information that's been further used or disclosed without authorization. So that's where one unauthorized access or disclosure happens, and then the person goes off and does something else with it. Easy example is they go off and they try to make money off the information that they have. That first use wasn't something that had to be reported, but you now have reason to believe that they're going to go off and sell that information to get further, to make money or to do something else with it. So that would also have to be reported to the IPC. Breaches that are part of a pattern must be reported. Breaches related to disciplinary actions against a college or non-college member. As you know, there are a variety of regulated professionals that work in health information custodians as well as unregulated professionals. So this section links back to the section on regulated health professionals as well as unregulated health professionals. And if they're being disciplined in relation to a privacy breach, you have to be reported to the IPC. And then the last one is a sort of broad category or a factorial-based category of significant breaches, looking at the factors that are set out to determine, among other things, whether the breach warrants reporting. But this should not be taken to mean that all breaches have to be reported to the IPC. You may not have to report a breach if it's not intentional, if it's a one-off incident and not part of a pattern. Like this, try to get at the fact that some breaches that are accidental won't meet the reporting criteria, and some may be one-offs that aren't part of a broader pattern that don't have to be reported. Now, Sherry this is the page where my voice may drop because Sherry did want to emphasize some points here. Not every breach is significant. And when we start to talk about stats that the IPC receives, you'll see that we get a lot of breaches we get a lot of breaches reported to us as mailing errors or fax errors. And, well, some of those breaches may have to be reported to the IPC. A lot of them don't. Right? A mail out that goes to the wrong address, a fax that goes to the wrong address. If it's not part of a broader pattern, generally doesn't have to be reported. And the other point that Sherry wanted me to emphasize is that not every time you go into the wrong record, it's a breach. I think there's some people talking there's a perception that every time you go into the wrong record, if you're looking for Brendan Gray with an A and you end up with Brendan Gray, G-R-E-Y, and that somehow that's a breach. If you go into my record, if you go into the other Brendan Gray's record looking for this Brendan Gray, and that's not the case, right? The IPC has issued some decisions that point out that there are certain uses of information that are really expected as part of your ability to provide services, as part of your ability to have a roster of patients and locate the right person, and those aren't viewed as breaches. So if you start to see a lot of these, then you may have to report them, or you may have to start to look at whether there are breaches, or you may have reason to believe that this person's going into the wrong record for some other reason. and then again, it may meet some of the other breach reporting criteria. Now, what has actually been reported to the IPC? So as you know, we categorize breaches that are reported by HICS as self-reported breaches. Because we have different types of files. So we'll have like complaints, and we'll have commissioner-initiated files, where the commissioner initiates, our IPC initiates its own file. But now we're talking about self-reported breaches, so HR files. So we had 506 self-reported breaches in 2018, which is an over 50% increase from the year before mandatory reporting was fully in effect. What were they? 120 of them were snooping cases. 15 were ransomware cyber attack cases, and as those of you who've been with us for a long time know, that we've asked that all of those cases be reported to the IPC, those ransomware cyber attack cases. And then the others were sort of a mixed bag of lost or stolen PHI, misdirected information like those misdirected faxes, records not properly secured, so records that have been left out for someone to see, and other collection use and disclosure issues. So now I'm breaking up the files that the IPC had last year. So the turquoise, more than half of that pie chart, are self-reported breaches. And you can see that those are the ones we just talked about, the 506. But what other files did the IPC have last year? Orange is collection use disclosures. We have other just complaints where people will call our office, right into our office, and make a written complaint that their information has been collected without authorization, someone shouldn't have been using it, it's been disclosed. We get a fair amount of complaints about that, 128 of them. We also get a lot of access correction issues. And then the smallest group of those are the IPC-initiated ones. And those are the ones where the IPC learns of a privacy breach some other way and then opens its own file, generally. And I realize now, as I look out over the crowd, that there are several of the IPC intake analysts here who actually have to deal with this stuff. So it sort of feels like I'm telling you what you guys actually do on a daily basis. But this is these are Sherry's slides. This is not me. Yes. Yes. I mean, you don't have to apologize for not being free. I mean, things are bad at the Federation right now, but they're not that bad. Yeah. Yeah. So, like, we categorize them under PHIPA, an access correction request that is denied comes to our office as a complaint. Other offices talk about these as an appeal, but essentially it's someone who I have gone to a custodian and said, I would like access to this record. And the custodian has said no, or given some partial access, or the person has been somehow dissatisfied with their response. Correction, I've gotten access to a record, I want to correct it. Often this HIC will say, the custodian will say, well, it's not incomplete or inaccurate for the purposes for which I have the information, or I use the information, or it's been professional judgment, or one of those exceptions that are set out under Ontario law, and then they'll complain to our office about it. So we get a fair amount of those as well, but yeah, that's what that was referring to. And I also, please do interrupt me at any point in time, because I'm looking through these slides, and Sherry talks at about half the speed that I talk, and I'm a bit worried that when she was pacing this, she was pacing it for herself, and now I realize that I may be done in 22 minutes. So, we're going to get through this together, and we're all going to tell Sherry that we made up the full hour, all right? This is what this is going to work. So now PHIPA files open year over year. This is meant to give you a year-over-year comparison of the total number of files that the IPC is dealing with. And I realize that as I'm giving you this presentation, it really sounds, this is like a pitch for me to be asking you for more money. Like, this is the kind of pitch that someone gives a board where they're like, look at how our numbers have increased. I'm ready for more, But seriously, if you want to put a hat around, we could collect some additional funding. So, of the privacy breaches, the first year that PHIPA was fully in force, as many of you will know, was 2005. So in that year, how many files were opened by the IPC? 177. So 5 years after that, 288. This is including all files, so access correction, self-reported, commissioner-initiated. 5 years after that, 460. And now, 2018, 870. So it's fair to say there's been a pretty significant increase in the number of complaints that we've been getting, which is why we need so many hardworking people. So what I was talking about there was mandatory point-in-time reporting, right? So you have to report breaches at the point at which they occur in certain circumstances. There's a whole other obligation which came into effect in 2018, for the calendar year 2018, which is annual statistical reporting. So that's after the end of every year, you have to report your breaches in certain categories to the IPC, and this catches all of the breaches, not just those that meet the criteria for point-in-time reporting to the commissioner. So the categories are generally lost, stolen, used without authority, disclosed without authority. Those are really broader categories and catch really all breaches. Anytime you have to notify the individual, you got to put a mark in your annual report or your statistical reporting for the last year to make sure you track that breach and then report it to the IPC. And what does that show? That shows that there were 11,278 incidents of health breaches reported to the IPC in 2018. So that's a fair number. What were a lot of them? There were a lot of unauthorized disclosures, and you can see that by the second bullet there, a lot of them were just misdirected faxes. So it's 381 of them were misdirected faxes. So it still is a very significant issue, and you should be aware that the IPC will be putting out a guidance document on fax, I believe next year, to sort of try to help get some clarity around faxes and that issue, but it's, as you can see, that faxes remain a fairly significant source of privacy breaches in Ontario. Other categories are fairly small. You look at things like, there's other unauthorized disclosures, like mailing errors, those types of misdirected phone calls, that type of thing. But then there's also stolen PHI, lost PHI, and unauthorized uses, those snooping cases. Now we get into what I view as the fun slides. What are the decisions that the IPC has issued in the last year, and what can they tell us about the IPC's thinking about various topics? So PHIPA Decision 80. So this is a case where an individual, there was clinical concerns in relation to the care provided to the husband, but then there was also this sort of related privacy concern that arose in the hospital's investigation of the clinical concerns. So there was a concern that the doctor had breached the husband's privacy in speaking to a third party about the care provided to the husband. The complaints were made to the hospital and to the CPSO, the College of Physicians and Surgeons. The College of Physicians and Surgeons, I believe it was their Inquiries, Complaints, and Reports Committee, issued a decision. That decision was then appealed to HPARB, to the Health Professions Appeal and Review Board, and HPARB issued another decision affirming the CPSO's decision. The individual then also filed, or I'm not sure about the exact timing, but filed a complaint with the IPC under PHIPA. And the point here is that the IPC found that there was no need to review the matter as it had already been dealt with by the CPSO and HPARB. So those of you that respond to frontline patient complaints will know that there are a lot of different places individuals can go to make complaints about some clinical issues, but also privacy issues. You can go a variety of different places, especially for issues of professionalism, professional conduct. And the IPC has discretion not to review certain types of, not to review complaints where it's been appropriately dealt with somewhere else. So that's in section 57.4 of PHIPA. So those of you that are responding to these complaints or dealing with them, you may be able to look at this decision, see if there's an argument you can make from there about why maybe a complaint shouldn't proceed. So PHIPA Decision 82, this is where a hospital was responding to a media request for information about a deceased patient. And again, this had also been the subject of a decision by HPARB. This was a case that had been in the media in the locality in which this case had arisen, and there was a fair amount of media attention in relation to a deceased patient and the patient's family, and the hospital, in an attempt to allay some of these concerns in the local community, started to disclose the patient's personal health information without consent. And this case really got on this issue of what was and what was not already publicly known. There were, a lot of what they said was just a repetition and a referral to facts that were already in an HPARP decision. And for those, the IPC held, that's not a disclosure, this is information that's already publicly out there. That's not a disclosure of additional information in an HPARP decision. But the hospital went farther and disclosed some additional information. And the IPC found that that was not authorized. So in this case, there was some discussion around whether the information in the HPARP decision was personal health information, and the IPC found that it was, and the hospital was directed to amend some of its policies. Now, the other point to recognize about this decision is, did the hospital really have to do what it did? Right? The hospital, I think it's fair to say, could have saved itself a fair amount of grief if it had not gone about disclosing information in the way that it had in the wake of a patient's death. So, while some disclosures or some of the facts here were found not to be contraventions of PHIPA, you can put a question mark next to, or I guess I'm hinting at a little bit broader than a question mark, about that the hospital probably could have found a better way to allay the fears of the public than to disclose the exact information that it did. So this is a case of dealing with unintentional and unauthorized access. This is where an individual believed that a physician and other staff had inappropriately accessed her personal health information. The hospital conducted a number of audits, and they communicated the results to the patient. And the adjudicator found that the accesses were the purpose of providing or assisting in the provision of health care to the individual. So really what we're getting at here is that the physician, in this case, had inadvertently clicked on more tabs in the electronic EMR than they actually needed to click on. And this case concluded that no review was warranted, this wasn't an intentional and unauthorized access, and no order was issued in this case. So this may come up in your practices where you find someone who's clicked on, maybe they were providing healthcare, but maybe they clicked on more than they needed to. They clicked on a tab, some additional tabs. You may want to refer back to this decision. Yes. Unfortunately, I can't recall. I'm sorry to say, I can't recall exactly if we will get into, not about this case, but if you want to talk about timing and audits, come to my plenary session after this. But other than that, I can't remember if, I'm sure there's some other good sessions at the same time. I can't remember what they are, but I'm just joking. But I will talk about that. But in this case, I'm afraid I can't remember. Yeah. 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 Yeah, I've seen those exact same cases. I know Anita has a question, but yeah, I've seen those exact same cases where you say, okay, I clicked on it, and then you say, okay, well, they were in it for 3 minutes, they were in it for 4 minutes, they were in it for 10 minutes, they were in it for an hour, and you say, well, then the person says, well, I walked away from my desk. Did I walk away from did I walk away? Was I still there? And then you say, well, did you click on anything after that? What was happening with the computer at that point in time? And those can be like some pretty, I've seen those cases. Can't recall how it played out in this one, I'm sorry to say. Yes, Anita. No, I don't think it is. I mean, I think I'm loath to speak for the adjudicator. Like those are the words that are in the statute. Those are the words that were in the decision. But I believe they're really getting at the fact that they were. I read this decision, and let me sort of give you my 2 cents about what I would say. Like, as part of that line of cases, and Sherry gave me the number I should specifically refer to. Should that question come up, Anita? She doesn't just throw me in here with nothing. I think PHIPA Decision 44, which was the case that dealt with like, scrolling through records when you're trying to find the right patient. And in that case, the IPC found that this is really sort of the ancillary patient, roster that you have to keep in order to find the right information, and that this was, in this case, was factually sort of similar to that. That we're really talking about, when you're going into a record and you're clicking through information in order to find the right information. If you click on the wrong tab on your way to the right tab, is that a problem? That's the way I've interpreted it, or that's the way I understand, but that's the way I think about it anyway. Now, this is a case that I hope you do ask questions about, because I have all sorts of things to talk about on it. It's this discretionary disclosure of a non-custodial parent. So this is a case that I think many of you will have seen cases like this if you work for a hospital. A non-custodial father had requested access to his child's records, and the hospital had denied it, saying that he wasn't the child's substitute decision maker under PHIPA. And as many of you will know, the PHIPA substitute decision making provisions for capable children do not make a non-custodial father to be a substitute decision maker for the capable child. And so the father was not the substitute decision maker under PHIPA, and didn't have a right of access. But in the course of making his request to the hospital, the father raised a whole series of other arguments. The father said that he had had the mother's consent. The mother was the custodial parent and was the appropriate SDM who could have consented to this disclosure. There also was a court order, which arguably entitled him to the information that he sought. And he also referred to other statutes, and those of you that practice and are familiar with family law will know that there's provisions of the Divorce Act, and I believe it's of the Children's Law Reform Act, all of which speak to these issues. So what the adjudicator did in this case was said, hospital, you dealt with this as an access complaint, and you said father didn't have a right of access, which, let's assume that that's true. That's not the whole issue. The rest of the issue is, was there a basis upon which you could have disclosed the information to the father under different provisions of PHIPA? And for example, you didn't consider the mother's consent. You didn't consider the court order, and you didn't consider the other statutes that could have permitted this disclosure. And the adjudicator ordered the custodian to go back and consider these other authorizations. And now, at the risk of going off on a tangent of my own, as many of you will know, there's this distinction in PHIPA between an access and a disclosure. Right? That there's provisions of the Act that are built up around access and mandatory requirements to provide access, subject to limited exceptions. But there's also other provisions that deal with when you can disclose personal health information to an individual. And there's a whole series of authorizations there. And the IPC has, in a line of cases that I believe in 2016, dealt with the IPC's authority to review discretionary disclosures. I say discretionary in the sense that PHIPA doesn't mandate the disclosure. That doesn't necessarily mean that you're not, for example, required by law to make the disclosure, because, for example, a court order would otherwise require you to make the disclosure. And there may be cases where you have to go back and look at that. Now, anticipating a question that may come, does this mean that in every single case where someone walks into my office and demands access to a record that they're not entitled to, that I have to go back and consider all the provisions of PHIPA that authorize disclosures that might apply? Like, do I have to go consider all of the, maybe they need it for their own health care. Do I have to go back and consider that? Do I have to go back and consider all the other potential statutory authorizations that are out there under 431H? The answer to that is no. Like, we're not saying that you have to go out in every single case and consider every single other potential statutory authorization that there could be. But in this case, there were some pretty clear ones that the father directed the hospital to, and they didn't consider it. Or the adjudicator found that they had not adequately considered it. Yes? Mm-hmm. Yes, so there may be cases where you just may not know, like PHIPA allows you to rely on an assertion that someone makes. And if they say, I'm the parent of so-and-so, and PHIPA allows you to rely on an assertion that someone has made, that they're a substitute decision maker. Now, from my prior life, where I used to give advice to doctors on this stuff, when one parent comes in, it's always best to say, like, hold on a second, are you guys, don't want to pry, but are you guys together or are you not? Like, yeah. 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 Yeah, so it's always tricky when you're dealing with parents in those circumstances. And really, when you're dealing with a child, really look at, did you have a reason to believe that person was not authorized to make the request? But you also have to look at what the person told to you. Like if they represent to you that they're a person who's authorized to make the request as a custodial parent, that's one thing. If they're just saying, I'm any old parent, like I tend to think that, let me put it this way, if a complaint came to the IPC and there was someone who said, they came in by themselves and they said, I'm a parent, and no one asked, well, are you the custodial parent or are you not? There may be some further questions that are asked. It's always best to know what the family situation is like. Often for family physicians or hospitals, like those things are pretty easily done. And I should also point out that the SDM provisions of PHIPA, I was careful to say capable child, because often when there's incapable children, there's other hierarchies of substitute decision makers that are found. Yes, Anita. Now, the exact timing at which the father provided the information, I can't recall if he provided it, like, there's different time periods. There's when he initially made the request versus as part of the IPC's process. And I can't recall if he gave it to them beforehand or as part of the IPC's processes, but there certainly was evidence of all those things before the IPC. Yes. Yeah, did the evidence definitively show that the mother had consented? That question was not decided, but there were things that he pointed to that suggested that the mother had consented, and there was some evidence that he provided, as I recall, as well as provisions of court orders, and statutes is an easy one. But in that case is different than the case that you've been. The first question I received there wasn't any question about whether the parents were were not together. Right? There is no question that the father was not the custodial parent. You may have heard of this one. This one, the IPC was contacted by media about the use of surveillance cameras in an examination room of a cosmetic surgery clinic. So you may have heard of this. It was in the press a little while ago. It was in the press again, and it was in the press, I think, earlier this week, again. The clinic, in this case, operated 24 security cameras that recorded 24 hours a day, and I guess here's the kicker, in examination rooms, in operating rooms, pre-op rooms, as well as reception and administrative areas. So the 24-hour surveillance cameras operating in examination rooms raises, I think for anybody, a few really quick issues about why are you doing that. The central purpose of the system was not healthcare, but for the security of the clinic, staff and patients. And the IPC found that although there were some security concerns, that didn't justify broad-scale, intrusive security cameras everywhere. So, oh yes. It was a cosmetic surgery clinic, private cosmetic surgery clinic. So not a hospital, not just your regular old doctor's office. And the IPC found that the clinic's practices contravened the Personal Health Information Protection Act. And I think it's a A quick look at Section 30 about data minimization would show that. There's also issues around consent, like what is the actual legal authority for this collection. But what did the clinic do at the time? The clinic limited the hours and the number of cameras. So by the time that the file was done, the clinic had in fact, based on some dealings with the CPSO, had limited the hours that the clinics were recording to just after clinic hours. So the clinic was worried about thefts after hours. The cameras are only on after hours. Limiting the number of cameras to at the 2 entrances, and in that way not recording PHI because there wouldn't be patients, it wouldn't be catching patients with the view of the cameras in those circumstances, was what the clinic indicated. The clinic would confirm the destruction of all footage that had been recorded prior to January 2019, except for some footage that had been seized by the CPSO. So the CPSO had already come in and taken some footage, and they said, everything else will be destroyed. The CPSO obviously has its own investigative process, and that shouldn't be destroyed, but that'll go on, and when that comes back, we'll destroy it, subject to our legal obligation to retain it. And then there may be, they improved their notices and had some improvements to their privacy policies. Now, this is one that this decision I think will relate to a variety of the other sessions that are happening today. And this is about a shared system dealing with dozens and dozens of health information custodians and the HIMPI rules of PHIPA and how the IPC has read all these things together. I know there are a variety of people today talking about privacy programs and other types of shared system issues and agreements. So I think that this would be a very useful decision for people to have reference to. What happened? So the IPC received breach reports from 3 separate custodians, though really what we're talking about is a shared system that involves dozens of custodians. The IPC took a broader look at the entire system for looking for systemic issues and had gone through some of our previous decisions or previous privacy breach reports to look at whether there were issues that had been unresolved. And really what you see is a large selection of the types of breaches that we get. You looked at there were unauthorized accesses to family members, friends, ex-spouses, agents, high-profile patients, and these tend to be in smaller settings or like regional hubs or smaller community hospitals. And the decision goes into some of the risks of shared systems. The first risk to recognize is that custodians don't have sole custody or control of PHI in a shared system. The custody control is shared, and that can pose some pretty unique challenges for compliance with PHIPA. Who is responsible for doing all the different things that PHIPA requires you to do? And an easy example, and one that came up in this case, is who's required to notify individuals of privacy breaches. You may have a privacy breach that goes from an individual at one health information custodian accesses information at another health information custodian without authorization, and it's detected. Who's supposed to report that to the patient? Is it the HIC who had custody and control of the information? Is it the HIC on whose behalf the agent was acting? And in this case, there was some confusion and some individuals were not notified. And shared systems to the IPC also raise these increased risks because generally speaking, everyone has access to the information on the shared system. It's all agents of all HICs will have access to any individual. And that creates some temptation for people who are interested in snooping into records. And it also can attract hackers because they can get access to just a lot more information for less work. So we spent a lot of time, and this is really a case about working with the HIMPI, the hospital that was the health information network provider, and the various hospitals, and it's their steering committee to come up with solutions to problems. There are issues with staff training, there are issues with consistent auditing practices across the hospitals and other HICs, and timely notification of breaches. There are deficiencies that were found, but the custodians agreed to fix them, so there wasn't actually a further review that was conducted in this case. And as I mentioned, one of the custodians was the health information network provider, so this decision spends a fair amount of time talking about what is the role of the HIMPI and how does it legally comply with its obligations. And what were the lessons learned? I guess the first one is that you have to have harmonized policies. If you're in a shared system, you have to have harmonized policies because otherwise it's not going to work. You have to have, everyone has to know what they are permitted to do in the system. How individuals are going to request access to information is another common issue that comes up on shared systems. Can I go to any HIC as participating in the shared system to get access to my record? Or do I have to go to the one that has custody control over that bit of information? And that should be addressed, and that's often a point of confusion. Training is a big issue too. When you say, I as one hospital am letting another hospital's agents into my record, how am I ensuring that those other individuals that I'm just giving access credentials to my record actually know what they're allowed to do? Because as we'll go ahead and if you attend the other session I'm going to be giving on this particular decision, there's, generally speaking, shared systems, you're allowed to access information for the purpose of providing healthcare. How do you make sure people know that? How do you make sure people don't try to access information here for other educational purposes from other health information custodians, other risk management purposes that may not be authorized? There's also auditing issues. How do you make sure that auditing across the shared system is done in a way which is effective? Am I auditing my own agents? Am I auditing your agents? Am I auditing my own patients? Are you auditing your patients? How do we make sure that across all of this pooled PHI, we're actually have an effective measure of preventing or detecting and deterring unauthorized access? Now I'm going to talk about some of the guidance that was issued in 2019. Avoiding abandoned records. Now, from what I know about the attendees to this conference, this is not going to be a problem. Generally, people who are abandoning their records, I don't think attend conferences like this. But, maybe some of you are planning on, but there's issues about abandoned records that come up to the IPC fairly frequently. It's often private clinics or small custodians. Obviously, sometimes there are issues of varying degrees of blameworthiness. Sometimes individuals die, right? So when in the event of death, PHIPA has provisions that speak to who becomes the custodian. Bankruptcy, again, there's issues around who becomes the custodian. And transfer to other custodians. There's also group practice issues. You can have many HICs working together or many physicians working together, but then one of them tries to leave and they haven't really adequately thought out who is going to be the custodian of these records and who is actually authorized to take records with me when I go. And we see a lot of cases where individuals are just, they left, and then the old group practice is complaining about them to the IPC, and then the physician who left is complaining about the old group practice to the IPC, and they've all gone off to court to fight about their contractual rights, and really now old group practice of physicians and leaving physician are all now fighting about who is entitled to keep which patient record. I don't know if you've seen those cases. I've seen a fair amount of them. So really what this guidance document is talking about is how do you avoid these types of abandoned records. It also talks about, clarify some of the obligations on custodians to obviously retain information securely, take reasonable steps, notify individuals of a transfer. If you're transferring records between a successor under PHIPA, you have to notify. And I guess the biggest takeaway is have a succession plan, right? That's the easiest way to avoid records being left entirely to the wind, which does happen. Yes? Okay. Yeah, so the first case I'd refer you to is PHIPA Decision 29, and if I'm wrong about that number, it's only off by one. Maybe it's 3028. No, it's 29. But that decision talked about a case where a physician had died, and PHIPA deems that the physician's estate trustee is now the custodian of the records. So the physician's estate trustee had entered into a contract with a different, if I recall, it was a different document management company or a record storage company, and then that record storage company had scanned all the information and there was a whole issue about whether they could have scanned it, which I don't take to be your question. But ultimately, that case found that the document management company was the agent of the estate trustee who remained the HIC, and the estate trustee was still accountable for that information, with the result that this was really just a request for access of an agent of a custodian in that case. Now, you could end up with a whole lot of other very interesting fact scenarios talking about these types of record storage companies and how, like, that case was a pretty clean example where there was someone who was a custodian, who was still around, and who was deemed to be a custodian and had entered into a contract with that company. There's a lot of other cases that we come across, and I'm sure you've come across, which are much more difficult, in tracing legally through the authorization, because under PHIPA, where you have custodians can only charge certain fees. But then the question becomes, are these people, what are they? Are you an agent of a custodian, are you not? Now, this case I referred to, 29, found that they were an agent of a custodian. But you could imagine much more complicated scenarios where the path of the records into the document management company is less clear. And now, I mean, I think my personal view is we try to read PHIPA in a way that provides protection to patients in the way that it was meant to be read, but as a remedial statute. But there's also some other examples that I'd be more than happy to talk with you about after this that really get into the nuts and bolts of, like, how do you actually read the statute in a way that, are these companies always agents of custodians? Are they something else? Are they electronic service providers? Are they this whole other series of things that we can get into? But great question. Yes, Anita? Yeah. Mm-hmm. Mm-hmm. Yeah. Mm-hmm. Yeah. Yeah. I mean, Anita is right that a lot of college policies do talk about these things. So talk about what could be charged, like where a document management, like planning for successions. Now, I don't claim to know exactly what all those fees are, because in Ontario, at least, there is a series of IPC decisions interpreting what is reasonable cost recovery. And then if you were to compare those fees with these fees, they are consistent? All right. All right. Yeah. First of all, you guys have done a great job, because, like, I would be done these slides a long time ago, and it's like 11. It's like was it 1:45? Yeah, you had a question, I believe. Yeah. 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 I mean, like, I can tell you that. Outside of my role at the IPC, I've heard of, and also in my role at the IPC, I've heard of costs that are significantly higher than that. I mean, just thinking of, the costs that, am I allowed to say this? Thinking of family member who paid costs between, like, the transfer of records between their old family physician and a new family physician. And I'm like, well, that doesn't seem like that was authorized, but they paid it. And, family doesn't always take your advice. Sorry, were there any other questions on that? So avoiding abandoned records, there's a guidance document on that. Accessing the PI of deceased relatives. So we have a guidance document on that as well. For those of you that are familiar with PHIPA, it has some fairly detailed sections on accessing PI or PHI of a deceased individual and who has authority to do what. But there's also, as those of you that deal with FIPA know that there is, it's a bit more, what do we say, open to interpretation. In FIPA, the provisions are a little bit less, in my view, concrete. So this case talks about some of the things you would consider when you're giving when someone wants access to their deceased relative's PI or PHI. And the same issue comes up about whether the person is the authorized substitute decision maker or whether they are someone else who may be entitled to the information for other reasons. Like FIPA talks about compassionate grounds. PHIPA has other provisions that talk about things like if you need the access to the information for your own health care, the easy example is you want to know information about like genetic conditions, that type of thing. So there can be other issues that come up even if you're not the authorized substitute decision maker. Yes, Simeon? Yeah. Mm. Mm-hmm. Yeah. Mm-hmm. Well, PHIPA says that if you die, the person who can access and act on your behalf, your SDM is your estate trustee, or if there is no estate trustee, the person who has assumed the responsibility of administering your estate in the absence of an estate trustee, right? So, like, then the next question becomes, how do you prove that I am the person who that Brendan has died, does not have a will, does not have an estate trustee, and who is the person who's been administering my stuff? And that is in those circumstances where I see people give affidavits. Like they give an affidavit saying, you know, I've lived with Brendan for the last 20 years. Brendan didn't have a will. He died. I've been the one I've gone and closed up his bank account. I'm the one who's been managing his personal possessions. I'm like, you can get into those types of nitty-gritty things about what the person has actually done. And other cases where you're like, I'm the one who made the arrangements with the funeral home to deal with Brendan's body. I'm the one that arranged his funeral. So those are the types of things that often come up. But yeah, you can prove that you can give evidence to show that Brendan doesn't have a will, Brendan doesn't have an estate trustee, so no one, my will doesn't appoint my estate trustee, no one has applied to court to be the estate trustee without a will. That's the way it works in Ontario, I'm not sure about other provinces. And then, and that there's no one else, and I've been managing Brendan's property. Nothing exonerates the hick. Let's just take issue with that choice of words. But the point is, where a hick, like hicks have to have reasonable grounds for believing the person has the authority that they have. All right. So if I come to one of your clinics or one of your health centers, and I provide you with an affidavit that says that, the next question that most lawyers would then, if you start thinking legal advice, the question is, well, all right, this person has said this. Does that meet the elements of that section? Probably. Do you have any reason to doubt that? Yes, no, and then you really go down that analysis. But often an affidavit will be enough just to show that this person is the person who is doing that thing. Now, I've never personally seen a case where two people have come forward and said, like, I managed Brendan's body, but I managed his collection of whatever. We're both, like, there's fights between, actually, no, that's not true. As I've been talking about that, I actually have seen that case. So, correction, I have seen that case. But you do see cases where there are examples where people are fighting over who is the actual person who is managing your estate. Now, PHIPA says that person is your estate trustee. And an affidavit, like, the takeaway is you want some proof that the person is actually doing that, and an affidavit is a good way to prove it. Sworn statement. Yes? So first of all, excellent question. I'm going to try to, the really short answer is the IPC, as far as I know, has never adjudicated that specific question under PHIPA. I'm going to give you a bunch of other reasons. But first I'm going to tell the joke of whenever anyone says, is it the IPC's position when I'm subbing in for someone else, I immediately get like, I immediately be like, well, what would Sherry say? So I'm not going to give you the IPC's position, but because there isn't one. The question is an excellent one because, as you point out, like PHIPA says when you're dead, your estate trustee becomes your SDM. And nothing in PHIPA specifically says only if they're acting in their capacity as an estate trustee. You might be able to arguably read that in. Now, I'm sure Anita knows, but there are cases under PHIPA which do say that, which read into the equivalent PHIPA provision, which talks about personal representative, that you have to be acting in that capacity and by implication not off on a whim of your own. As far as I'm aware, those cases have never been read into PHIPA. Now, there are other PHIPA mechanisms that arguably you could start to talk about. Like PHIPA has provisions that talk about like Form Gs. So for those of you that are familiar with the Healthcare Consent Act and mental health law, there are provisions in which you can bring forms to the Consent and Capacity Board where a substitute decision maker is not acting in accordance with the person's wishes. Though the reading of PHIPA is, let's say, unclear, or it would appear that those provisions don't seem to apply to access requests. Yeah, I mean, it's... Well, I mean, in a variety of like, let me put it this way, there's a whole body of case law built up with Form Gs, where people talk in the healthcare consent context, where you talk about what are, well, let me just finish there, because those are people who have been, in many cases, incapable or unconscious for some time. So, I mean, I'm not sure that it's as inappropriate a comparison as you have suggested, because there's a lot of cases about what people have said when they are alive, and ultimately that's how those cases are decided. Yeah. And PHIPA, like, I think, but the issue is a live one, right? Like, what happens when those cases come up and you say, but mom didn't want her son to know that she was dealing with this particular psychotic issue at this point in time. And the other problem is PHIPA doesn't really say that you're not entitled to get access in those circumstances. In fact, it suggests that it's just the estate trustee, full stop. So I think you've pointed to all the right places for what the tension is there, but all I can tell you right now is the IPC has never adjudicated that matter. And if it were to come up, as it may have already come up in your practice, you look at the issues of, you could look at those PHIPA case law and try to argue that something comparable is in PHIPA, but then the counter argument to that will be that PHIPA doesn't have those similar qualifications that are built into it, and there are some good reasons for thinking that estate trustees shouldn't be limited in that way because they may need to get access to information for a whole series of other reasons that are, where they are getting access, like the issues around like insurance payments and those types of things that come out around death, that should they be forced to justify why they're giving access in each case, or why they're requesting access in each case. Yes, Anita. Yeah, you're right. Yeah. Yeah, I mean, these are good points. Let me say that. Unfortunately, I don't have the answer for you. I saw Dustin raising his hand, which I think means that I'm almost done, but I'm going to just quickly say, we now have a 3-year reviews webpage. I hope that none of you actually have to deal with the 3-year reviews. I have to deal with them, as is, I think I saw a smile from Nicole in the back, as Nicole has to deal with them as well. But for the rest of you that don't have to, there's a webpage now that talks about 3-year reviews for organizations like, I'm going to say Cancer Care Ontario, but Cancer Care Ontario started to be Ontario Health as of yesterday, didn't it, Anita? So, and there's some other organizations as well, like ISIS. So if you want to see some of those documents, we now have one dedicated webpage for that. And what's ahead for 2020? Oh, you can all look forward to the CYFSA. Now, as many of you will know, the CYFSA is coming into effect on January 1st. Part 10 of it, which is the information part, which is largely modeled after PHIPA, except for the child youth and family services sector. Now, if you're a HIC, odds are it's not going to do anything for you because there's an exclusion for HICs. Most of the provisions don't apply to you if you're a health information custodian, but it's still an important thing to know, especially if you deal with child family services information. You may not be HIC in some of your capacities, in which case you may end up with this statute applying to you. And what's ahead for 2020? Oh, the 3-year reviews. So I'm now looking around to realize that there's more people in this room who have to do the 3-year reviews, and we're all working ahead on 3-year reviews of the prescribed entities and prescribed persons under PHIPA. So that's Ontario Health, formerly Cancer Care Ontario, ISIS, and a whole bunch of others, which is a ton of work for both people for the entities and prescribed persons as well as in PHIPA. We're updating our posters, so if you put those up in your custodian in your offices, we can get some more of them. We have new documents on disclosure of PHI to law enforcement, updated facts guidelines that I mentioned earlier, guidelines for researchers and REBs, which I don't think we've ever had before, and updating some other PHIPA documents. Like, we're constantly updating these because there's been, those of you that are really nerds and have been following legislative changes, there's been a variety of legislative changes to PHIPA in the last year. So there's our contact information. I'm sorry if I rushed anyone through the questions, but yeah, that's the end of it.